You get sort of a bonus episode this week. I will be probably recording a quote normal episode on Friday, is my guess. But as I said, I wanted to read Dobbs, and now that I have read it yesterday, I wanted to go through it while it was somewhat fresh. Also, by the way, I record these like intro things after the fact, so that's why sometimes when I'm doing something like this, it sounds like, hey, he's repeating himself because that's how I know what I'm going to say in the show, in the intro, because I don't always know what I'm going to say. Anyway, also no video this week. A few technical issues to still work out. Hopefully, I'll get it fixed and we'll have video ready to roll on Friday. Anyway, that's all. Let's start the show. Welcome back to Reasoned Refrain, where it is my goal for you to know what you believe and why you believe it, and to preach the gospel of resurrection by grace alone, through faith alone, over and over again. I am your host, Stephen Curto. Please stop writing back to the show at stephen@reasonedrefrain.com. I am so just never ever send messages to Stephen@reasonedrefrain.com. That's Stephen, Stephen, the correct spelling, at reasonedrefrain.com. Drink of the day is a Speyside that I'm going to have trouble pronouncing. Kregalachi, I believe, is what it is. And it's a fairly old Edward and Mackey Speyside single malt Scotch, and it is good. It's got how to describe it. It's got a little bit more of the wheat and kind of more of your Highland leaning Speysides. Not as much fruit or honey as some of your other Speysides, like a Dalmore or a Balvenie or a Glenlivet on the fruit side. It's good though. It's different in very subtle ways. Kind of really does strike me as a Scotch drinker's Speyside, where lots of Speysides end up being kind of like your introductory non-Scotch drinkers' Scotches. This one has a little bit more subtlety to it, and not as many of the on the nose pleasant tastes, flavors. We've got a unique show. It's just gonna be one long meat segment. Like I said last week, finally got a chance to read the Dobbs decision, so that's all we're gonna talk about. But I'll go ahead and get into the meat segment.
The meat segment.
Yes! Can we eat something's flesh? I want meat!
All right. So I did get the chance to read the Dobbs decision. Let me adjust that. I didn't actually read the entire decision. I read all of the opinion of the court, and I read Thomas's concurring opinion and Roberts's concurring opinion. This is one of the longer Supreme Court decisions that I've ever seen. It's 213-page long PDF when you download it. And Alito wrote the opinion of the court. It was a 6-3 decision. For anybody who doesn't know, this is, I don't know how you wouldn't know, but the Supreme Court recently overturned Roe V Wade. Roe V Wade was a decision that was established back in, 1973? I really am talking purely off the top of my head on a lot of these facts. All I have in front of me is the decision and my summary of it. So 1973, I believe, Roe V Wade was decided, which was dealing with a Texas law that put limitations on abortion after the first trimester. And Roe v. Wade basically said states can't limit abortion up to viability. They were trying to find a viability standard. And what made Roe v. Wade such a terrible decision, apart from just the moral repugnance of it, was the fact that it was so poorly argued. You can go and go to mygivonthings.com and search Roe v. Wade, and I believe that the article I wrote on that one was abortion isn't legal. That was the title of it, where I just walked through the argument presented in Roe v. Wade. It was astonishingly bad. They tried to say that the Constitution guaranteed a right, and they said we're not really sure if it's in the Ninth Amendment or the 14th Amendment or scattered through some of the other amendments, but we're pretty sure it's in there, and that's only a very slight exaggeration of the argumentation that they made. So Roe v. Wade happened. Casey, Planned Parenthood versus Casey was the second case that sort of ratified or upheld Roe. I believe it was in 1992. Again, going off of memory, so please don't shoot the messenger if I got some dates wrong. Planned Parenthood v. Casey argued more directly that it was found in the right to abortion was found in the 14th Amendment. And we're going to read the 14th Amendment real quick. Let's go find it. 14th Amendment, Constitution text. The text of the 14th Amendment of the Constitution says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now that phrase, nor shall the state deprive any person of life, liberty, or property without due process of law, is the phrase that Casey and many other Supreme Court decisions have hinged on down through the years. I teach hermeneutics. Basically, you take that one word, liberty, and you just pour into it whatever meaning you want. And then you say, well, the state can't deprive me of that. State can't deprive me of that. And so my liberty allows me to do X, Y, or Z, and you can't stop me from doing that. So what are you going to do about it? And that's the basic argumentation of Casey, is I have the liberty to kill my child, and the state can't do anything about it because the 14th Amendment says that the state shall not deprive any person of life, liberty, or property, and I have the freedom to do what I want with my body. And if that means kill a person with my body, then I get to. That was the argument of Casey. So that's kind of the backdrop. 1973, 1992, 60 some odd million abortions later, and here we are. Dobbs versus the Jackson Women's Health Organization, this pregnancy center in Mississippi it's the state legislature of Mississippi wanted to create a law that would restrict abortion after 15 weeks. They said 15 weeks and later, no abortions. The Mississippi law said, and there were a couple of reasons. Alito's decision that he wrote in the Dobbs case, stating the opinion of the court, is a masterclass in logical, tight argumentation for a particular point. He gives zero wiggle room. He defines his terms clearly, he uses them consistently, and then he backs up every point that he makes. So I want to just kind of give you a walkthrough of what the decision actually said and what it doesn't say. And so he starts out with, let me get over to my little summary of the opinion and get the opinion up in front of me. It starts out, the opinion consists of, I think it was 7 sections. First he gives a little preamble, sort of walking through the history of abortion in the United States. A very brief history, where he just does basically what I just told you about the two previous cases as far as the court was concerned. And he explains in brief what the decision of the court was. And so this one paragraph worth reading. We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That's the one I just read you. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be, quote, deeply rooted in this nation's history and tradition, end quote, and, quote, implicit in the concept of ordered liberty, end quote. And this is, these quotations are from another Supreme Court case, Washington versus Glucksberg, in 1997. This is the basic thing that the court ruled, that Roe and Casey must be overruled because it does not meet the standard set forth in case law for a right that could be found within that liberty thing in the state shall not deprive any person of liberty. That is what the court found. That is basically all the court found, and that is the one contention that Alito sets out to prove in his opinion, in the opinion of the court. It does not meet the standards to ground a right to abortion in the 14th Amendment. And on top of that, it does not meet the standard to ground the right to abortion in the 9th Amendment. But the reality is that the people who were bringing this case, the people who were arguing for abortion, they were going, Casey said it's in the 14th Amendment. We think the 14th Amendment's our best bet. We're arguing for the 14th Amendment. That's where we find this right. And the flip side was saying, no, it's not there. So the first section summarizes the arguments of the two people. But before that, there's another paragraph worth reading right at the end of the introduction before he gets to the 7 sections. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. Quote, the permissibility of abortion and the limitations upon it are to be resolved like most important questions in our democracy by citizens trying to persuade one another and then voting. And that was a quote from the Casey decision, a concurring opinion in not a concurring opinion, a dissenting opinion. Scalia, concurring in judgment in part and dissenting in part. It's a quote from Scalia's concurrence/dissent in the Casey decision. That is what the Constitution and the rule of law demand. The first section summarizes the two arguments, and I'm not going to read huge swaths of it. I'll read just little bits. But basically, the Mississippi law argued that look, we're unique in how liberal our abortion laws are. There's all of these reasons that there's all of these different functions and things of how a person develops, all of these different markers of humanness. From 5 weeks all the way on up to 12 weeks. And they were saying that D&E abortions, that's, what is the summary? Dilution, something in evacuation. I'm going to get it. Dilation and evacuation, that's it. Dilation and evacuation abortions are the ones that are performed usually 15 weeks and after. And that's the one where you dilate the cervix, stick up some forceps up the woman's womb and rip pieces of the baby out until you get all of the pieces. You literally rip the child limb from limb inside the womb. that's a D&E abortion. And those are the ones that are performed pretty much exclusively after 15 weeks. And so the Mississippi law was saying, look, D&E abortions are cruel and unusual punishment. They're barbaric and dangerous to both the woman and obviously to the child who's being ripped apart. And so we want to ban abortions after 15 weeks. Basically, we want to ban D&E abortions, was what the law argued. Not far enough, in my opinion, but it got the case up to the Supreme Court. The Jehu, I'll back up, the Jackson Women's Health Organization and its representatives, I found really, I was interested because Jehu, obviously phonetically, J-W-H-O, so the word who, preceded by the letter J, is actually the name of a particularly brutal king of the northern tribes of Israel in the Bible. If you don't know, his conquest was ordained by God, and it was quite graphic and brutal, and he was an evil king sent by God for judgment. So it just struck me as kind of funny that the people who were arguing for abortion, for specifically D&E abortions and abortion all the way up till birth, their name phonetically, so I'm going to call him Jehu throughout. Feel free to roll your eyes at me for that, but so what? The Jehu argued 15 weeks is prior to viability, and viability is the earliest possible constitutionally adequate marker. They were saying, look, if you want to try and make any kind of limitation, you gotta draw the line at viability, because that's when a baby could be, an independent human. Further, though, they specifically said that banning. So the last little bit in section 1, respondents, that's Jehu, answer that allowing Mississippi to ban pre-viability abortions would be no different than overruling Casey and Roe entirely. They tell us that, quote, no half measures, unquote, are available. We must either reaffirm or overrule Roe and Casey. This is Scalia's summary of their argument. They're basically saying, look, if you want to listen, court, if you want to rule in favor of the Mississippi law, then you got to completely overrule Roe and Casey. If you care about stare decisis court precedent at all, then you can't let these people set a 15-week ban, because that's pre-viability, and so you're just a sham of a court. I'm paraphrasing. Right? Those were the two sides. The decision then, obviously, they decided to overrule Roe and Casey. Casey, let's see. So section 2. Section 2 is the longest, or maybe the second longest section. It outlines most of the argument that has to be addressed. And so he says, we're going to turn to the question that the Casey plurality did not consider, and we addressed that question in 3 steps. So he takes 3 steps that make the body of his argument. And the 3 steps are basically going to look at 3 different questions or ideas. The first one being the standard that our cases have used in determining whether the 14th Amendment's reference to, quote, liberty protects a particular right. Basically, he's going to look through history and say, what's been the rule that's applied to decide if something is an unnamed right within the 14th Amendment, that no state can deprive a person of life, liberty, or property. So in section 1A, he goes through, section A1. In section A of the first section, he walks through the history of finding that answer. The second thing, so A is dealing with that question. What's the standard that our cases have used in determining whether the 14th Amendment's reference to liberty protects a particular right? And then B whether the right at issue in this case is rooted in our nation's history and tradition, and whether it is an essential component of what we have described as, quote, ordered liberty. So that's the second thing that he's going to interact with, determine. And then part C, we consider whether a right to obtain an abortion is part of a broader, entrenched right that is supported by other precedents, i.e., is it protected by a right to privacy, like Roe said in the Ninth Amendment? So parts A and B are very obviously dealing with Casey, the argumentation in Casey that it's part of the 14th Amendment, and that's what the main respondents were arguing for. That's part of the 14th Amendment. So the bulk of his argument is dealing with can you say abortion is covered by the 14th Amendment? Do you have a right to abortion because the 14th Amendment says you have a right to liberty without interference from the state? And he puts on a masterclass of walking through the history and showing, okay, here's our nation has always said that if you're going to say something's grounded in the 14th Amendment, liberty, it has to be, what are the two phrases? It has to be rooted in our nation's history and tradition. That's one phrase that you'll hear a lot throughout this thing. And then an essential component of what we would call ordered liberty. Not just liberty. It's not just like freedom to do anything. That's not what you have. That's not the liberty that you're not free to kill other people. You're not free to steal from somebody. You're not free to rape, pillage, and plunder. Those are freedoms you do not have, even though the 14th Amendment says that the state will not infringe your right to liberty. It's ordered liberty, and it's liberty. If you're going to say that this is something that's protected by the 14th Amendment, then it's something that is rooted in our history and our nation's history and tradition. So part A, he goes through and shows point after point down through the ages that this phrase of rooted in our nation's history and tradition is essential in determining whether or not something can be found in a right can be found in the 14th Amendment. Let me skim through and see if there's anything. Casey said abortion is in the 14th Amendment. Due process, some people argue that. Due process clause protects two categories of substantive rights. So first in this section A, he says, look, Roe said it could be found maybe in the 9th Amendment, maybe in the 14th Amendment, maybe somewhere else. We don't know. Casey said it's in the 14th Amendment, and so let's see if it's in the 14th Amendment. So A2 deals with whether or not it's found in the 14th Amendment. And he says due process clauses protect two categories of substantive rights. Those explicitly mentioned in the first 8 amendments, right? Right to freedom of assembly, right to bear arms, and the like. And then a select list of fundamental rights not mentioned anywhere in the Constitution. So that second category of unnamed or unenumerated rights might be found in the due process clause of the 14th Amendment. And then he says, to decide if a right is in the due process clause, the second category, the court has long asked whether the right is deeply rooted in our history's nation and tradition, and whether, quote, it is essential to our nation's scheme of ordered liberty. And all through this thing, he drops little nuggets that are just right hooks to the liberals, in both on the court and out in the general public. And this is one of the first big right hooks that he drops. He says, look, this is the rule. It's got to be deeply rooted in their nation's history and tradition, and it's got to be essential to our nation's scheme of ordered liberty. This is how we've always treated it. And then he quotes RBG. He quotes Ginsburg in one of her decisions, in one of her cases, who used those exact phrases, that a 14th Amendment right has to be deeply rooted in our history and tradition and essential to our nation's scheme of ordered liberty. And RBG said that it went all the way back to the Magna Carta. This is how far back this test goes. And I wanted to read a couple of portions of this. So in A2, when he's talking about in interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what the amendment protects with our own ardent views about the liberty that Americans should enjoy. On occasion, when the court has ignored the appropriate limits imposed by, quote, respect for the teachings of history, unquote, it has fallen into the freewheeling judicial policymaking that characterized discredited decisions such as Lochner versus New York. Now, interesting side note, I actually think Lochner versus New York was rightly decided. Lochner versus New York, I think, is a fascinating case that's worth looking into. And this is one of the things that I found kind of funny or interesting, or maybe a knock against the Dobbs decision, is that he repeatedly referred to Lochner as if it's obviously a discredited and bad decision. I'm going, well, wait a second. Don't be so hasty. But that aside, after that, he says, the court must not fall prey to such an unprincipled approach. Instead, guided by the history and tradition that map the essential components of our nation's concept of ordered liberty, we must ask what the 14th Amendment means by the term liberty. When we engage in that inquiry in the present case, the clear answer is that the 14th Amendment does not protect the right to an abortion. That's section A. In dealing with the question, does the standard, or what is the standard that our cases have used in determining whether the 14th Amendment's reference to liberty protects a particular right, in this case abortion? And the conclusion is, no, it doesn't. It just doesn't. And he listed so many different things. He went back to the Magna Carta, back to Blackstone's commentaries. He showed there is no argument you can really make that abortion was a protected right in anyone's mind until Roe v. Wade. The earliest case that you can cite, the earliest quotation really in any kind of legal literature that you can cite that is pro-abortion in any way, was in 1968, like 5 years before Roe. And so that's his point, is the concept that abortion is a right guaranteed to people at all is very, very new. It came about at Roe, and it is not deeply rooted within our nation's history. You just can't make that argument. You can try and make other arguments, but you can't make that one. And that's the one that Jehu decided to make. And that's what Section B is all about. He walks through everything. We begin with common law, under which abortion was a crime at least after quickening. Sir Edward Coke's 17th century treatise likewise asserted that abortion of a quick child was murder if the child be born alive, and a great misprison if the child dieth in her body. The Three Institutes of Laws of England in 1644, he cites he makes citation after citation, showing very clearly that the law was quite consistent that no, abortion was not a right until the 70s. And Roe and Casey completely ignored that history. He makes this point. That Roe and Casey basically just said, look, we don't care what the history says. He said, the court's opinion in Roe itself convincingly refutes the notion that the abortion liberty is deeply rooted in the history and tradition of our people. And that was quoting White's dissent in Thornburr versus American College of Obstetricians and Gynecologists. He finishes B2 with the inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. The court in Roe could have said of abortion exactly what Glucksberg said of assisted suicide. Attitudes toward abortion have changed since Bracton, but our laws have consistently condemned and continue to prohibit that practice. He then addresses some rebuttals and basically says, look, the other side, they got nothing. They have nothing. And he starts off it. Respondents and their amici have no persuasive answer to this historical evidence. They don't. It's just a fact. The history is on the side of anti-abortion people. Another kind of funny little aside. In trying to say, oh, no, there's a precedent for pro-abortion prior to Roe, people on Roe's actual legal team viewed the precedents, the scholarship of the articles that they were citing as quite spurious. An internal memorandum characterized this author's work as donning the guise of impartial scholarship while advancing the proper ideological goals. This is what Roe's team thought of the scholars they were citing in order to get Roe through the court and make abortion legal. And I thought that quote was I'm so glad that he included that quote in here, that the pro-abortion scholarship was donning the guise of impartial scholarship while advancing the proper ideological goals. Could you more aptly summarize essentially all modern scholarship? It's not about actually applying a process and going where the evidence takes you. It's about finding the right answer that your benefactors want you to find. Yeah, I just found that a fascinating little aside. One may disagree with this belief, and our decision is not based on any view about when a state should regard prenatal life as having rights or legally cognizable interests. But even Roe and Casey did not question the good faith of abortion opponents. This is one part of the decision where I'm going, interesting. So this is where it makes very clear, look, I'm not arguing on the basis of this is right or wrong. I'm arguing on the basis of the argument that you guys put forward that this is a constitutional right, and it's not. And I want to be really clear. What this decision said was abortion is not a constitutional right, and that's all it said. It just said, look, you don't have a constitutionally protected right to abortion. It's just not in there, which is true, which is accurate. It did not go on to say anything about whether or not a preborn human is in fact a human and has inalienable rights. It didn't say that the 14th Amendment does apply to that baby's life. And this is one thing that I found really fascinating, that the people on both sides were kind of making this point. That's all it said. And I think that's correct because, well, I think that's correct? Let me back up. I think it's silly that the Supreme Court decided that it has for itself the authority and responsibility to interpret the Constitution. I don't think that the Supreme Court has that role. I think that Marbury v. Madison was wrongly decided, and that the concept of judicial review just is not part of the Supreme Court's purview. But put that aside for a second. Since the Supreme Court took for itself the responsibility of authoritatively interpreting the Constitution, this case is built on the concept that the Supreme Court has the authority to interpret the Constitution, and it's saying, look, the Constitution does not protect abortion anywhere in it, most certainly not in the 14th Amendment. That's the conclusion. Instead of seriously pressing the argument that the abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right. Roe termed this as a right to privacy, and Casey described it as the freedom to make, quote, intimate and personal choices, unquote, that are, quote, central to personal dignity and autonomy, unquote. Casey elaborated, and this quote from Casey is just flabbergasting. Casey in, 1993, said, "At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life." That was part of the decision-making in a Supreme Court case on whether or not we can kill babies. And it's said at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. It sounds more like the ramblings of a 12-year-old girl's diary than it does a Supreme Court ruling. And Alito has a great little comment. So right after quoting Casey, he says, "The court did not claim that this broadly framed right is absolute, and no such claim would be plausible. While individuals are certainly free to think and to say what they wish about, quote, existence and, quote, meaning and, quote, the universe and, quote, the mystery of human life, unquote, they are not always free to act in accordance with those thoughts. License to act on the basis of such beliefs may correspond to one of the many understandings of liberty, but is certainly not ordered liberty." And that's kind of the main thrust of Part C, where he's basically saying, look, is the right to an abortion found anywhere else in the Constitution other than the 14th Amendment? Parts A and B are dealing mostly with the 14th Amendment. Part C is saying anywhere else, and the answer is nope. A bunch of other rights that aren't abortion are supposedly used to justify a right to abortion. And he goes through and says, look, there's the concept of ordered liberty is nothing new in case law. It sets limits and defines the boundaries between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed, quote, potential life. And this is something that's really important. He comes back to this repeatedly, that Roe and Casey both used the phrase, quote, potential life to describe the baby that is being killed. And this is kind of what he grounds his final determination of why is this case different than all these others. Because this one is dealing with potential life. The people of various states may evaluate those interests differently. In some states, voters may believe that the abortion right should be even more extensive than the right that Roe and Casey recognized. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an unborn human being. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. He then goes through and lists a bunch of cases that pro-aborts use to say, well, look, these are our liberties that are found elsewhere in the Constitution, and that other cases have found basically in the Due Process Clause and elsewhere. This section is trying to give more jabs at the left, who is saying, look, if you get rid of abortion rights, based on this argumentation, you got to get rid of all these other rights that courts have found based in the 14th Amendment and elsewhere. Like, if abortion goes, then we're gonna go back to outlawing interracial marriage next. You have heard many a left-wing pundit make that case. They're going to overturn Griswold, and they're going to overturn Obergefell, and they're going to overturn Lawrence, and you're not going to be able to have interracial marriages anymore. And Alito specifically addresses that ad nauseum. He lists all of these cases and says, these attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. Those criteria at a high level of generality could license fundamental rights to illicit drugs, drug use, prostitution, and the like. What sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both those decisions acknowledge. Abortion destroys what those decisions call, quote, potential life, unquote, and what the law at issue in this case regards as the life of an, quote, unborn human being, unquote. None of the other decisions cited by Roe and Casey involve the critical moral question posed by abortion. They are therefore inapposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right does not undermine them in any way. So he draws a real hard line and says, look, Obergefell, Griswold, I'm just going to list some of these. So Loving versus Virginia, the right to marry while in prison. Turner versus Safely, the right to obtain contraceptives. Griswold versus Kentucky. Loving versus Virginia is interracial marriage. Turner versus Safely, the right to contraception is Griswold and Eisenstadt. The right to reside with relatives is Moore versus East Cleveland. The right to make decisions about the education of one's child is Pierce versus Society of Sisters. The right not to be sterilized without consent, Skinner versus Oklahoma. Justice Oliver Wendell Holmes wrote the decision. And then of course you cap it off with Lawrence versus Texas, the right to have sex with whoever you want as long as it's consensual, which is a terribly decided case, and Obergefell versus Hodges, the right to marry a person of the same sex. And he's saying, look, this case, Roe and Casey and Dobbs, the question of abortion is different categorically than those other rights because we're dealing with potential human life, and those other rights are not dealing with potential human life. So it's apples and oranges. It's a category error. You don't get to make that argument. Then he moves on to part D. Last little bit of that question of part C. Both sides make important policy arguments, but supporters of Roe and Casey must show that this court has the authority to weigh those arguments and decide how abortion may be regulated in the states. They have failed to make that showing, and we thus return the power to weigh those arguments to the people and their elected representatives. A strong, clear statement. Section D. The dissent is very candid that it cannot show that a constitutional right to abortion has any foundation, let alone a deeply rooted one in this nation's history and tradition. Again, quoting Glucksberg. The dissent say that. They're like, yeah, it doesn't meet the standard that this court has always held. So what are we even doing here? They're like, yeah, you're absolutely right. The rule that has always guided whether or not a right is found in the 14th Amendment can't be applied to this. It doesn't apply and got no foundation. Abortion isn't a right deeply rooted in the nation's history and tradition. All right. If that's the case, this should be a 9-0 decision. But for some reason, it's not. And here's the reason. The main thing that the dissent says is stare decisis, stare decisis, stare decisis, stare decisis. Stare decisis is the concept that court precedent matters and court precedent must be followed, bar none. I'll back up. Stare decisis is the concept that if a case has already been decided, you rule in favor of the previous decision unless there is a particular grounds to overrule a previous decision. Basically, you care enough about what previous generations have said that you don't just chuck it out at the first opportunity. That's what stare decisis really says. And early on in this opinion, Alito said, if stare decisis had been properly applied, it would have required an assessment of the strength of the grounds on which Roe was based in Casey, right? Casey, in determining its decision, looked to Roe and said, well, Roe's already decided this question, so stare decisis, so we got to rule in favor of abortion. And Alito makes a really great, just brilliantly lays out the fact that Well, Casey wasn't following true stare decisis. True stare decisis doesn't just look at the decision, but the argumentation upon which the decision is based. And the argumentation upon which Roe was decided is so shoddy. It's terrible. It's just bad argumentation. And so the concept that, well, the dissent is going to vote in favor of abortion because, well, Roe and Casey and stare decisis, but Casey was decided on stare decisis and Roe was decided on bad argumentation. So you're just perpetuating a mistake. You're perpetuating a lie, a bad argument, a bad decision. And what's really great, I mean, he spends a lot of pages just dismantling the left's entire argument based on stare decisis, and he gives 5 reasons to overrule Roe and Casey. 1, the nature of the court's error, that it was just wrong because it was deciding about human life. 2, the quality of the reasoning, which is what I was just talking about, was that Roe was just so bad. 3, the workability of the rules they imposed, which is something that Casey did a little bit about. Like, okay, if you're going to make this law, you have to make it workable. It has to function in reality, and the reality is not workable. 4, their disruptive effect on other areas of law. Right, when you decide this way, it's a seamless garment, so to speak, and so it brings along friends. And 5, the absence of concrete reliance. There are a lot of pages on this that are basically dismantling the left's whole argument on the basis of stare decisis. But he starts it off with all he really needs to do, which is basically saying, okay, this is what you're saying is the court should never get to overturn any of its decisions. So you want to go back to Plessy versus Ferguson, I guess. Right? Like, all you got to do is say, so you're in favor of Plessy v. Ferguson, yes? Brown versus Board of Education should not have overturned Plessy v. Ferguson? Because, I mean, stare decisis, the case was decided. That's all you have to do. And it's like, if that's your only argument, the case is already decided in stare decisis, and so we never overturn a bad decision. You're saying that the court can never make a bad decision, and that no previous overrulings were legitimate or right. So you are if you're arguing for Roe based solely on the basis of stare decisis, then you have to logically also be in favor of Plessy v. Ferguson and various others. And what he does great here, great and bad in my opinion, is he lists 3 examples of cases that the liberals, of course, very much so, are in favor of overruling. He lists Plessy v. Ferguson and West Coast Hotel versus Parish, which made a minimum wage a thing, and effectively overturned Lochner, like I mentioned before. And he mentioned, so I mean, the left is all about minimum wage, and so you're like, if you're saying we can't overturn this one, we also West Coast Hotel versus Parish couldn't have overturned Adkins versus Children's Hospital. That you're not allowed to have minimum wage. And then he also listed, which was just a brilliant move. The last case he listed was one that probably isn't very familiar. Like, you might have heard of West Coast Hotel. You almost definitely have heard of Brown versus Board of Education and Plessy v. Ferguson if you're familiar with the Supreme Court at all. But then he also listed West Virginia versus Barnett, which overturned Monersville versus Gobitis, which made it illegal to force public school students to salute the flag in violation of their sincerely held beliefs. So he cited this case that said, well, look, here's a case way back in history that said you have to salute the flag. You leftists are all about, kneeling and how the flag is racist and how we need to free speech and you don't have to honor the flag. Well, stare decisis. You want to go to where we force people to salute to the flag. What are you going to do? He picked cases to actually explain that were so obviously like, well, of course the liberal judges want to overturn those bad decisions, and then he footnotes all of the rest of them, and it's 2 pages of footnote. And like the one footnote goes 2 pages long, listing all of the cases that have overturned bad previous rulings. And it's like, obviously, your argument that stare decisis means that we can't overturn Roe and Casey is stupid. That's kind of the end of section 3. How many pages are we in? Okay, so section 4. He goes through. Let me remind myself. Get back to the beginning of section 4. I highlighted different portions of each one to read. 5 Casey. Where are you? There's B, the quality of the reasoning. Okay, so those are the 5. The section where he's going through the 5 reasons why you should overrule Roe it was very long. Section 4. Having shown that traditional stare decisis factors do not weigh in favor of retaining Roe or Casey. I mean, he really showed it. We must address one final argument that featured prominently in the Casey plurality opinion. The argument was cast in different terms, but stated simply, it was essentially as follows. The American people's belief in the rule of law would be shaken if they lost respect for this court as an institution that decides important cases based on principle, not, quote, social and political pressures. Basically, he's saying, look, there's one last little bit that I have to address here. If we overturn previous precedent, does that mean that the American people's faith will be shaken in our court's ability to be objective, to be principled, to make decisions based on reasons, not based on emotion? And really simply put, that's just dumb. The way that you retain the perception of principled decision-making is by making well-argued principled decisions, not by caving to public pressure. So the argument in Casey was basically like, look, the public will be outraged if we overturn something. They won't trust us. We have to cave to public pressure. And he's saying, no. The way that you maintain a degree of confidence from the public is precisely not by caving to public pressure, precisely by making well-argued principled decisions. And that's what he's done here. He's laid out 70 pages of argumentation that are just so rock solid that you can't, if you actually go read the decision, it's like, yeah, well, there's no other choice. You clearly have to overrule Roe and Casey. And he summarizes section 4 with, we therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. Section 5, then, starts with, the dissent argues that we have abandoned stare decisis, but we have done no such thing, and it is the dissent's understanding of stare decisis that breaks with tradition. The dissent's foundational contention is that the court should never, or perhaps almost never, overrule an egregiously wrong constitutional decision. He basically defends himself against some silly arguments. And indeed, the dissent even eventually admits that a decision could be overruled just because it is terribly wrong, though the dissent does not explain when that would be so. You gotta love it when somebody makes a concession without conceding anything. Section 6 then says, what rule are we going to follow? Right? If we're going to undo Roe v. Wade, what rule are we going to follow? And he basically just says, we're going to follow letting the states decide. State legislatures, you get to decide how you're going to regulate abortion. And then section 7 is just a brief little recap And the brief recap is the Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. Couple of appendices. So that's the decision in a nutshell. I would really recommend it. It takes an hour or two to actually read it, but I would recommend going and reading it. You can go and just download it on supremecourt.gov. You go to their opinions page and you go to recent opinions and you can find Dobbs v. Jehu and download the PDF just like I did and read the decision. Read the argument. The argument basically didn't really comment on whether abortion is right or wrong. It's obviously wrong, but it didn't comment on that. It just said, look, the previously decided court cases that said that this is found in the Constitution were wrong. It's not found in the Constitution. And here is an irrefutable argument for why it's not found in the Constitution. I wanted to briefly go through Thomas's concurring opinion, because he just... Thomas has a way of cutting through the doo-doo. Can I say that on this show? He's got a way of just saying what he means. And Thomas was like, I know that Alito said that, look, we're like, this case does not have any bearing on any other cases. And he's right. This case does not have any bearing on any of the cases because of the way that he argued. It was so rock solid. It was well done. He gives a little golf clap to Alito. And he's like, but I'm saying it. I'm saying that we should definitely look at overturning some of these other bad court cases that were based on the 14th Amendment. These court cases that wrongly interpreted the 14th Amendment. He says, I write separately to emphasize a second, more fundamental reason why there is no abortion guarantee lurking in the Due Process Clause. Considerable historical evidence indicates that due process of law merely required executive and judicial actors to comply with legislative enactments and the common law when depriving a person of life, liberty, or property. Other sources, by contrast, suggest that due process of law prohibited legislatures, quote, from authorizing the deprivation of a person's life, liberty, or property without providing him the customary procedures to which free men were entitled by the old law of England. Either way, the Due Process Clause at most guarantees process. It does not, as the court's substantive due process cases suppose, quote, forbid the government to infringe certain fundamental liberty interests at all, no matter what process is provided. Quoting Reno v. Flores, as I have previously explained, substantive due process is an oxymoron that lacks any basis in the Constitution. And he quotes himself in the various cases where he's made this claim. Because the Due Process Clause does not secure any substantive rights, it does not secure a right to abortion. That's his basic argument. It's like, look, the 14th Amendment, you can't use it to say that any right is guaranteed. Therefore, you can't say that it's used to guarantee the right to abortion. All of these cases throughout history that have said there's a right guaranteed by the 14th Amendment, and he lists some of these, and there are a bunch of the ones that Alito listed in the whole, like, well, if you get rid of Roe v. Wade, you also have to get rid of some of these. And he was saying, no, you don't have to. And Thomas is like, okay, the argument you laid out, you don't have to, but you kind of should, like, separately. Yeah, we should overturn these things because they're not found in the Constitution. Cases like Griswold versus Connecticut, the right of married people to obtain contraceptives. Lawrence versus Texas, the right to engage in private consensual sexual acts. And Obergefell versus Hodges, the right to same-sex marriage. Yeah, he's saying, look, those are all based on bad argumentation from the 14th Amendment, and those should all be undone. Skipping down a little bit in his concurring opinion, the Planned Parenthood versus in Casey, the court likewise identified an abortion guaranteed in the liberty protected by the 14th Amendment, but rather than a, quote, right of privacy, end quote, it invoked an ethereal, quote, right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. I love that they both quoted that, because that is so, it's unbelievable that was not only that was in a Supreme Court decision, but that was the basis of the decision. Like, that was their core thrust of the argument, was like, you have to have the right to define the universe. Oh. As the court's preferred manifestation of liberty changed, so too did the test used to protect it, as Roe's author lamented. And he cites the author of Roe ruling later in Casey, concurring in part and dissenting in part, saying, look, we're changing the argumentation from Roe. This isn't stare decisis, this is bad argumentation. That 50 years have passed since Roe, and abortion advocates still cannot coherently articulate the right or rights at stake proves the obvious. The right to abortion is ultimately a policy goal in desperate search of a constitutional justification. Amen. Thank you. Thank you, Justice Thomas. His final little paragraph. Because the court properly applies our substantive due process precedents to reject the fabrication of a constitutional right to abortion, and because this case does not present the opportunity to reject substantive due process entirely, I join the court's opinion. But in future cases, we should follow the text of the Constitution, which sets forth certain substantive rights that cannot be taken away, and adds beyond that a right to due process when life, liberty, or property is to be taken away. Substantive due process conflicts with the textual command and has harmed our country in many ways. Accordingly, we should eliminate it from our jurisprudence at the earliest possible opportunity. Oh, it's just like you can just see the Thug Life glasses sliding down the screen and landing on us like, yeah, I want to overturn those other bad decisions. Of course I want to overturn those other bad decisions, and we should. Yeah. So anyway, the vote was 6-3. It was 5. It was 5, 1, and 3. 6 in favor of the Mississippi law. Roberts did not join Alito's opinion, the opinion of the court. He wrote his own concurring opinion of why he was still siding with the Mississippi law. But he basically said, well, look, we should just make it 15 weeks. That's what the Mississippi law says, and we shouldn't overturn previous precedent. Because that's pretty much how Roberts always argues, is something along the lines of Alito does a good job of basically slapping Roberts around a little bit in his own opinion, saying, look, the concurring opinion, and he says we will refer to it as the concurrence, even though, Thomas and Kavanaugh wrote concurring opinions. We all know which concurrence we're talking about. The concurrence, which said, well, let's just make abortion legal after 15 weeks, gives zero definition of terms. It's all so vague and stupid and infantile. It's clearly just like, well, let's all try to get along instead of just saying something clear and arguing for whether or not this thing actually is constitutional. And let's quote, leave it for a later date. And that's what Roberts specifically said in his concurrence. We can just leave this question for a later date. And Alito rightly points out, but that later date would be in 2 years. So you're just hoping that the country implodes or that you're not on the court anymore, so you don't have to decide in 2 years? Just grow a pair, man. It's seriously, what are you doing? Why are you even there, Chief Justice Roberts? Anyway. I've gone over my hour marker. That was all I wanted to spend talking about it. If you have any questions about the decision, things that I can answer, specific questions about what happens next, I would love to try and answer them as best I can, having read the decision. Like I said, I would recommend you go and read it yourself, but if you would like to just send me a question about it, you can do so by emailing Stephen@reasonedrefrain.com. That's Stephen, STEPHEN, at reasonedrefrain, REASONEDREFRAIN.com. Colossians 3:16, let the word of Christ dwell in you richly, teaching and admonishing one another in all wisdom, singing psalms and hymns and spiritual songs with thankfulness in your hearts to God. You'll hear me next time unless Jesus comes back before then. Reasoned Refrain is produced by Stephen Curto. The views and opinions expressed in this episode are my own and should not be taken as reflective of any institution with which I am associated. Theme song written and performed by J.J. Anderson and Stephen Curto, mastered by J.J. Anderson. Reasoned Refrain is the property of Stephen Curto, all rights reserved.